It's like go shining bright, colors dance in the night. You don't owe them a thing, it's not up for debate.
That right?
Hi, everybody. Welcome. We have Kathy InDieZoNe with us today, and there was a lot of information dropped. Hi, Kathy. Welcome.
My eyes are burning right now. I'm sorry, Audrey. You know, I cannot take what's going on this docket today. I'm very confused. I'm very concerned why none of these documents have been placed on the public record. And I have to say, I think the alibi defense is horrible. Sorry, Twiz. It was just a stupid thing to raise from day one. I knew that it was going to get struck. Judge Stephen J. Hippler has already determined that Cy Ray is not invited to the hearings on the 9th. And so therefore, I feel that this alibi defense is going to get struck because there's no way that Mr. Kohberger is going to take the stand. What are your thoughts, Audrey, on the matter?
I never thought that they were going to use the alibi defense. I always thought that they were going to use it as a placeholder because it's twofold. They're going to be able to show that information at trial anyway. So it doesn't really hurt to try it. And then at whatever point they decide, okay, this is really not going to work, they can switch to another type of alibi.
But who's
Hello,
in the car?
Amanda, welcome.
Hi, everybody.
Someone's in the car?
Okay, so Mr. Kohberger has to establish someone knew where he was at the time of the crimes other than him. Why raise it to begin with?
Hello, Anna D. I thought it was always just to keep their work product as far away as the prosecution as possible, stalling.
Well, unfortunately, there's a lot of people in the public who feel now very betrayed, very let down, and are actually, and I've had comments, I have the podcast on, where am I, Audrey? On Amazon and where else? I don't even remember where it is. It's multiple platforms. But I've had a lot of feedback today. People are disappointed, and they're jumping fence. They're feeling that, he's got to get on the stand, or they feel that, something's not right here.
So I feel if he doesn't, even if he's not able to use his alibi defense and he changes it to one of the other, what is there, 4 alibi defenses available?
No doubt. CSLI is the big one. But bigger than that was the alibi.
Well, he's going to be able to still show that information at trial. It's just not going to be in the form of the alibi. It's going to be as part of the regular trial. So no matter what, he's going to be able to show that information. And maybe that's the strongest information they have, even though it's not logistically or traditionally an alibi. So that information is going to get in there anyway, and we're still going to find out that he wasn't in Moscow.
Okay. So Diane, I want to thank Diane. I had 2 early followers back on when it was the InDieZoNe podcast on Amazon and LinkedIn and wherever we are, Apple. It was Diane. It was a guy from Tokyo who referred to Mr. Kohberger as Sensei Kohberger. So I want to thank Diane. She stuck with me for 2 years now.
Me too. Thank you, Diane. You're a great friend, and you are the best mod. You're very loved around here. Thank you.
How about when she said that her most trusted member of the Moscow Police Department was the dog? What was his name again, Diane?
Oh, yeah. Yeah. That's a good idea, Anna D. Anna D says, I think you might want to show Shy Ray's testimony on another case and show Nick Ballard's testimony. I think they'll understand more. Yeah, we can always do a future episode on that. It would be fun to sit and watch segments of different court hearings.
Audrey's going to be doing
Great
a lot.
recommendation.
Yeah, Audrey's going to be doing a lot more on the Idaho 4 case, right, Audrey?
Yes. Welcome back with Beats. Good to see you.
That's why he has. Yeah, very true. He does not have to take the Fifth Amendment. You know, he cannot be required to take the stand, but he did raise the alibi defense on his own. So that sort of takes him out of the Fifth Amendment. But now it looks like it's going to be dropped by the wayside. I do not see Judge Stephen J. Hippler granting him the opportunity to raise this defense. Judge Hippler does not put his neck on the line for any matter. We learned that with the motions to strike the DP, Audrey. Might I remind everyone of the same? That was back when, in October, right after a change of venue happened. Also with the suppression motions, the defense has lost every single battle. We can't hold it against them regarding the Franks motion because that Franks motion is impossible to get. However, with the hearings coming up on the 9th, Audrey, you going to do a show that day?
I believe I will. Yes.
Okay.
How about you?
Oh yeah, I'm going to be on. No doubt on internationally because of the podcast, but more importantly here in the United States. Yeah. That's the matter here is Judge Hippler will be taking the bench 9:00 a.m. Ada County time. Is anyone in the audience going to be there live by any chance?
Anybody named Twiz?
I don't know. I can't say that, but I've heard through the grapevine that certain parties will be attending the hearing. I can't confirm that, of course. However, many of these motions eliminate. Yes, we do not know what time the hearings will start and what motions eliminate hearings will be open to the public. However, Judge Stephen J. Hippler has released many of the in limine motions. Why would he not have them live at oral argument? So therefore, I'm predicting that the vast preponderance of all of these motions in limine oral argument will be on the YouTube channel of Ada County.
Oh, good. Oh, good. Well, Kathy, it sounds like Brian is going to have to change his defense anyway, especially because Hippler most likely will be like, you can't use this alibi.
So, 100%. 100% he's going to deny that. He's going to grant that motion. 100, ladies, I'm not a betting person, but I would bet right now that Judge Hippler will grant the state of Idaho's motion in limine regarding the alibi defense. If I could, be more certain, that's the one I think they're going to win on. So therefore, Audrey was very prudently saying, what, Audrey? You feel that he's going to have to change his defense strategy?
Yes. Here we go. I found some types. These are can we see this? Criminal defenses. I wonder if I can zoom in here.
Alibi, gone. That one's done. No insanity defense in Idaho. That one's gone. Mistake. Consent. Innovative. Mistake of fact. Innocent. Well, the only thing that he could really raise here is innocence. What's he going to say? Okay, he went in there and acted in self-defense against these 4 victims. No, not going to work.
And I think tried to raise constitutional violations, but that didn't really go out. What is this affirmative defense here?
Oh, wait a second. We have Miss Potts in the audience. I want to hear Miss Potts's thoughts
Miss
regarding.
Potts.
Hi, Miss Potts. I want to hear Miss Potts's thoughts regarding the possible loss of the alibi defense and what other defenses he could raise. I don't think he'd raise any other. No, he tried to raise the constitutional Fourth Amendment defense on the recent hearings. And unfortunately, again, they lost everyone, which I feel was very stupid on behalf of the defense because they failed to raise standing on the Fourth Amendment issue in the suppression motion. That's got to be, that's on Ann Taylor. Done. She lost that one. So that's out the window, Audrey. Therefore, we have to go back to intoxication. Was he drunk? Nope. Insanity, not working in Idaho. Necessity, mistake. What? He went into the wrong house? Nope. Got to be only innocence. That could be the only one.
Well, it could be that one, but it also could be this affirmative defense. So that he doesn't, the affirmative defenses are those which do not negate the specific elements of the criminal case, but offer a broader defense for the criminal charges. So maybe that's when they go into detail about these cell phone records. So maybe in a roundabout way, the cell phone data will actually be the defense because it'll be one of these affirmative ones.
It could be. It could be. And that's where Ray comes into play at that point regarding CSLI.
Yes.
Twiz gets it. Like he was mistaken. Yeah. Twizzle stick. Mistaken. That's out the window. That's out the window. Audrey, could we please go back to today's enormous findings on the case management page? I cannot believe what I saw today. We always knew that the 24th was going to be an extremely important day, but who thought that a new attorney would file a notice of appearance? What is this all about? Notice, Audrey, you see what I'm saying there? March 24th, 2025. Notice of appearance. Yep. Alan? Right. Who is that? What is that?
It's a notice of somebody. Somebody will appear, but I don't know who Alan is. Do you know who Alan is?
We don't know. Twiz, I don't know if his phone was off because I wasn't there. I'm sorry. I don't know. No, it's like, who knows if his phone intentionally or just went into a blind area. We don't know regarding his phone. We're going to need Ray to tell us that. But I am more importantly concerned about March 24th, 2025. Notice of appearance regarding Alan. Now, I looked to see if this document dropped on the public docket, and of course it has not. I sincerely hope that Judge Hippler will not withhold this document from the public. Oh, Twizzle number one. I'm very upset with you because you are no longer, comments on my page, either on YouTube or, should I also point out, the podcast as well. Yes, that is a very, if he drives out of service away from Moscow, can he come? Twizzle, I don't know. I don't purport to be an expert in this arena, but look at what Twizzle has said here. He said that he felt that maybe Beatty was trying to get off the case. Maybe a new one has come aboard. So this might be a new attorney for the prosecution, according to Twizzle. Oh, very good.
Beatty was trying. You're right.
So this might not be a member of the defense team, or, might I say, the media coalition. This might be a member of the prosecution team, because Ms. Beatty was looking to get off the case. Hi, Ms. Ram. We don't know
I
if it's
agree.
state or defense. We're speculating right now. Maybe one of the victim's family. Great point, Truth and Justice. Anna D has brought up an amazingly important point, because thus far we only have seen one attorney on behalf of the Gonzalez family enter an appearance in this case. Maybe this is a representative of one of the other victims' families. That is an excellent.
Ooh. Yes. Great, Anna D.
Right. No, I know. I mean, because there's three other victims' families, right? There's the Chapin family, the Mogan family, the Kernodle family, perhaps one of their attorneys. Or perhaps it could be an attorney for one of the surviving roommates.
Yeah.
We are going to have to continue to monitor this document, in the docket. There has been so much information that has been, sort of like, we can glean by looking in between the records. So we see here, Audrey, if we could please go down to show what else was docketed on the 24th, which was yesterday. And again, this is the case summary page. It hasn't yet hit the doc. There we go, right there. Motion to redact or seal newly filed records regarding the state's jury questionnaire proposals. We know we're getting close to trial when we start seeing stuff like this.
Mm-hmm.
These were due on the 24th per Judge Stephen Hipler's October 9th, 2024 pretrial and trial order. The jury questionnaires, unfortunately, filed under seal. There is a hearing on the 16th of April on the jury questionnaires, sealed to the public. So it's not going to be open. Therefore, it won't be on television. No one can go to the courthouse. But jury questionnaires, Audrey, you know what that is? The jury questionnaire?
Is that where they mail it out and they can eliminate the first round of jurors before they come in for the?
Well, that's like school. It's going to be administered to the citizens of Ada County that are called, yes, for potential jury duty, to help to serve as a tool regarding who will be selected to serve on this jury.
Oh, okay. Okay, thank you for clarifying that.
Yes, at 100%. I thought the same thing. Blackwood Beats and Outlaw Rhythms, who is saying, typically when a new attorney is brought on, it's made clear which side they're representing, especially if it's for the victim side. It's not stated. All the public knows is this attorney, Allen, Allen. What the heck is that? Audrey, could you bring it down just a few? It's up there. It's at the very top of the case summary page on your page. Oh,
Where, the notice of appearance?
yeah. Going back to Backwood Beats and Outlaw Rhythms comment. Who is Allen?
Truth and Justice Anna D asks, who's Bethany's lawyer? I don't know.
Yeah, that
That's a
was
good question.
Do we recall when in the 2023, when this matter was still in Latah County, that Bethany was subpoenaed to attend the preliminary hearing. She was out of state, so her attorney raised an objection, and then there was an agreement that she would speak with defense counsel. It appears that never happened. So we don't know who her lawyer is, but raising a good point. Could Alan be BF's lawyer? We are getting close to trial. And also, might I remind everyone, there are subpoenas for certain parties that have never been released to the public. Could this be for the hearing? Oh,
Miss
Madison
Potts says it might be Madison Allen, lead deputy AG out of Boise. Interesting, Miss Potts. Yeah.
Well, the issue here is we see here that is a PDF document. That tells us this is a public record. Unlike if you look at the item right underneath it, the state's jury questionnaire proposal, lock and key, under seal. Therefore, we will be apprised, or should be, who this notice of appearance is for, which side filed it, who Alan is, what Alan's role is going to be in this case, etc., etc.
So Miss Potts says Madison Allen graduated U of I, and her LinkedIn says she's the lead deputy AG, Attorney General.
U of I. U of I might be what? University of Idaho?
Mm-hmm.
Okay. Audrey, could we go down the case summary page a little bit more to look at some of the other documents that were filed today?
Yes.
Okay, lots of replies. Today, the 24th was the deadline for filing the replies in the in limine motions. States reply to defendant's objection to motion in limine rate, text messages, testimony. 911 call, we see that up there. Psychiatric evaluation. 911 call. Demonstrative exhibits. That's the model of 1122 King Road that they made.
The dollhouse, it's nicknamed.
It looks like it. Yeah.
Yeah.
Text messages. Magic question. You know what that is, Audrey?
Yes.
Voir dire. Okay, this tells us jury selection. The magic question is typically, even though after you've seen all the presentation of the evidence, do you feel that you could render a ruling based on the evidence and nothing else, i.e. pretrial publicity? Or should go down a little bit more? Mallory.
Ooh.
Mm-hmm.
Yeah, look at this.
I was very surprised to see that Detective Mallory will not be in the courtroom during the entire presentation of the guilt phase, aka the case in chief. There's two people who will be in the courtroom during the entire proceeding for the state of Idaho. Audrey, do you know who they are? Not Mallory. I'll tell you that right now. It's not him.
I don't remember who they are. Who are they, Kathy?
Well, one is an investigator out of Idaho State Police. Okay, that is one. He's an official with Idaho State Police. Then there is another representative, only he's not with Idaho State Police. And again, these are the two investigators who will be permitted to be in the courtroom during the entire proceeding, even before they testify. One is with Idaho State Police. The other is with Moscow Police Department. Allowed to be in the courtroom during the entire trial, Audrey. Who might that be from Moscow Police Department? It's not Mallory.
They're part-time.
Not Mallory. Oh.
Mr. Payne, how about that?
Who? Amanda Smith has correctly guessed that indeed Detective Brett Payne will be in the courtroom on camera during the entire trial.
Yeah, here we go.
Oh.
Twiz. Yeah, and everybody's.
Twizzlestick has been in the courtroom. I think when the matter was in Latah County, Twizzle, if I could be corrected if I'm wrong, were you not in the courtroom during the hearings on the very important motions for change of venue? August 2023. Yep, there he
Yes,
goes.
he was.
Courtroom. Okay. Was it just for that hearing, or were you also in the hearing prior to then? Yes.
Twiz says Beatty was by far their best attorney, in my opinion. I thought she was their only chance. I agree. I was a little worried that she was going to be on there because she's pretty good.
Okay, so Twizzlesticks is telling us that he went to every hearing. That means he was live in the courtroom.
Wow.
For every hearing after the alibi defense was announced. We would like to hear from Twizzle, please. If, what was it like being in there? What was his impressions of Bill Thompson, of Ann Taylor, of Brian Koberger, of Judge? Yes. Okay.
Yes,
but
I believe so, Miss Potts.
Mallory will not be in the courtroom during the trial. That's per Judge Stephen J. Hippler's order of March 4th, 2025, based on the stipulation between the state of Idaho and the defense that the state of Idaho will be bringing in Detective Brett Payne from the Moscow Police Department and another representative from the Idaho State Police, not Mallory. Okay. Okay. Could we go down further, please, Audrey, to look at some? These are all the items that were filed yesterday, the 24th of March 2025. They have not yet. The last time I looked at the docket, they were not published. These documents that you see here with the PDF icon, that should be a public document. They should be on the docket maybe tomorrow, maybe the day after. All these other items that you see sealed with the lock and key icon, forget it. Those are filed under seal. Hilly. Who's Gilbertson? Who's Hilly? I don't remember them. They must be expert witnesses for the state. Okay, if we could go down a little bit more. Audrey, please. Okay, so a lot of this looks like sealed documents, but there are many, 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 many filings that were filed publicly regarding the eliminate briefings, which leads me to conclude these hearings are going to be public. At least some of them will be. Oh, okay. Thanks, Ms. Potts. Okay, so we see here the reply. Now remember, when you see reply, what this means, that this is the third and final step in the briefings. It begins with motion, i.e. motion in limine. Then the other side files what's called a response in opposition and tries to convince Judge Hippler whatever the opponent filed regarding the originating motion, Judge, deny it. And here's the reason why. And then the person who filed the original motion files a reply. That is the last step, last word in the briefing. So see where we see here, defendant's reply to state's response, motion in limine number 2 regarding vague and undisclosed expert testimony, or the next one regarding use of the term M. Last phase, no further filings happen. Motion, response, reply. Then hearing, April 9th and 10th if necessary, and the Judge Hippler will rule.
I am looking forward to this one, the reply for the Riley Nolan touch and contact DNA for motion to eliminate number 6.
They have not, I have to bring this up. The defense has never, at least in my opinion, argued that DNA on the sheath was not Brian Kohberger's. It was more an argument of how did it get on there? Was it touch, transfer, something else? Contact.
Oh, welcome, One Maiden Nut. Welcome, Eddie. Good to see you. Welcome, Tom Campbell. Welcome, King.
Oh. Here we go. We
Good
have
to see you all.
Twizzle Stick providing his first-hand impression of what the courtroom was like when he physically went to the courthouse in Moscow, Latah County. He's saying BT was pretty quiet by that point. Everything in the courtroom was pretty chill. Despite most people's impressions, BK, AT, and Massoff do interact and talk. They have even touched him, LOL. Twizzle, what was your impression of Mr. Kohberger? Up close, mere feet away as you were from him. No one here has been in his presence, right? I certainly don't know who he is. Never met him. Have no idea who he is. But at least one person in your chat has.
So Twist says state claims his phone was off at 2:54. He thinks a siren AT can prove it's not off. The alibi should go on. And Miss Potts said something very. I like this, Miss Potts. She says they're arguing alternative perp secondary transfer, in my opinion. That is actually one of the defenses here.
Also,
And they call it Sadi.
the defense says they have not some, not a few, but many alternative perpetrators. I sincerely hope
True.
that this is not just some, off the wall theory, that they have evidence that will sustain objections under the Idaho rules for, evidentiary admissions. There's been plenty of time now to investigate these alternative perpetrators. But again, Audrey, they say they have not one, not a few, many alternative perpetrators. Now, what the state's asking, and I feel that this is not an unreasonable request, to provide a deadline, a reasonable deadline when the defense is going to submit this information regarding alternative perpetrators, because we have not seen it yet. I want to know who these alternative perpetrators are, not from YouTube providers, but from the defense.
Good point, Kathy. Yes, me too.
Who's he? Is this Brian Koberger? Just sits there, doesn't do much. See more in camera.
Yes.
How was his physical appearance, Twizzle? I mean, was he 6 feet tall? Larger? Did he seem, to be an impressive, physical figure to you? Or did he seem more slight, skinny? Except we understand that this would have been many months after November 13th, 2022. But still, you're the only person I think that we know of who has ever been in the same room with him. I think 6'2" is the shortest that he could be. Now, with those a size 13
Wow.
feet, yeah, we know from Commonwealth of Pennsylvania versus Koberger, which I advise anyone who has not seen those documents to go ahead and take a look at it, because you will see the affidavit of probable cause in Pennsylvania that was submitted to obtain the nighttime warrant, the exigent circumstances that allowed them to go in to the Koberger family home at 1:30 a.m. I didn't see a lot of things there that I thought I would see. But what we do know is that the Pennsylvania police found a size 13 pair of shoes belonging to Mr. Koberger. That seems to suggest he would be larger than 6 feet tall. What do you think, Audrey?
Yes. He looks larger than 6 feet. 6'2", 6'3", maybe.
Yeah, his legs look, even though his driver's license says 6 feet tall, who knows? That might have been obtained when he was a lot younger and then he just renewed it again. But he seems, just the size of those banana boats, 13 feet plus, just the way he's come across, he looks taller. He looks 6'2". He looks 6'2". I would not be surprised if his actual height were 6'2". He looked worse. Yes. Twizzle seems to say that he looked healthy in Latah County, different in Ada. I wonder if that's because Latah County was a more intimate environment. It was a basement. There was just a handful of prisoners there at the time. Ada County, another story. A lot more people. Maybe they're yelling things at him because he's infamous. He's on television all the time. So we can just imagine how the other inmates would treat him, Audrey. What do you think? In Ada County, where there are thousands of people that are incarcerated any day of the week.
Oh, I'm sure he gets lost in Ada. There's no personal attention. I'm sure it's chaotic. It's definitely in Latah. It was much more intimate and small, and it probably was a much nicer situation than what he has going on now.
Yeah. And you can just imagine him with all of the press attention. I mean, there's literally not a day that goes by, especially lately, where he's not named in mainstream media. And so, the other inmates might get jealous, might be, insulted. Why is he getting all this attention? Thinking that the attention he's getting is positive, and might have a few words to scream at him. So maybe that's why he looks thinner.
Ms. Potts says, how are you going to tell the defense to go look at lab report 3 for Eric's seat DNA analysis, and lab report 3 is for an alternative suspect? That is a great question.
That is really a good question. Could we go back to the documents that were filed today so we could show the people in chat what was filed?
Okay.
Here we go.
Let's see.
Defendant's reply. These are all the reply briefs. That's it. These hearings on the 9th, I guarantee, are going to be so important because it deals with what evidence will be allowed to be brought into the trial and what evidence will not be allowed to be brought into the trial. And I guarantee that if you watch Judge Hippler at hearing, you will get some Easter eggs from him as to how he's going. He's inclining to rule on these multiple motions. Amazon click evidence at trial. Unnoticed 404 evidence that has to do with the sheriff's deputy Duke stop in Moscow. Do you recall when people were saying, now, why would they stop him for a seatbelt violation? The in limine response from the state indicates that the sheriff's deputy Duke stopped Mr. Koberger in August 2022 due to speeding.
Yes.
He wasn't charged with speeding. He was charged only with violation of not having his seatbelt on.
No, I didn't realize that.
Yes, there we go. And there's no doubt Judge Hippler likes to pretend that he's poker faced, et cetera, at hearings.
Yeah.
I will guarantee he's going to give off some sort of body language. It might be a smirk. It might be, and he doesn't even, expect that he's doing this. But listen to the questions that there he is. There he is, Judge Hippler, also the administrative judge for Ada County. Sometimes he signs orders in Idaho versus Koberger as the administrative judge. I think that he does that unintentionally, forgetting he's not wearing his administrative judge hat. He is now wearing his district court hat in Idaho versus Koberger. But nonetheless, I must say, I think he's pretty fair. I think he lets people know what's expected of them. And I don't think that you're going to get a lot of surprises out of him. He's going to rule as the law requires. And the attorneys, whether it's Taylor, whether it's Thompson, or whoever is speaking up for the state, need to be prepared for these oral arguments on the 9th and 10th of April. pointing out whatever their 2 or 3 strongest points are regarding the in limine motions. Be prepared, anticipate what he's going to ask, and then sit down and be quiet. That's not the time to keep arguing your entire motion again. Hippler has shown the world what he expects. And yes, there's an opportunity for reversal on appeal, but only after there's a conviction and perhaps a prison sentence of many months, even years before that happens. And by the way, it's very difficult to overturn a jury verdict. That is a fact. This case, if it's going to be won by the state or the defense, it is going to be won here at the trial level. Now look at this. Defendant's reply to state's response to the defendant's motion in limine number 7, Ray witness identification by bushy eyebrows. This, of course, is the infamous declaration by DM of the intruder who had either 1 or 2 bushy eyebrows. She does not recall the color. Now let's look technically at what this is. Defendant's reply. This means what you're seeing right here, March 24th, 2025, is a filing that will be signed by Ann Taylor or someone else on behalf of the defense. Defendant's reply. What are they replying to? Tells us here. To the state's response to defendant's motion in limine number 7. So what's happened here is the defense filed the original motion, the state filed its response, and now the defense is filing its reply. Number 7 in limine, witness identification by bushy eyebrows. Begs the question, Audrey, what possible exculpatory evidence, as the defense has been talking about for many, 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 many months, could BF have that would be helpful to the defense?
I just thought of something on top of my head. It's probably not it. Maybe she saw someone that didn't have bushy eyebrows.
So you're thinking maybe she saw someone else?
She saw someone else. Yeah.
But how could she see
How about
anything
you?
if she is down on the first floor? Her bedroom is, think of the layout of the house. We know it's gone. We know it's gone, and it has been since December of 2023. However, you can picture in your head where Bethany's bedroom was, right? First floor to the left, facing cars in the parking lot. For her to walk out of her bedroom, she is literally has to walk past the stairwell from the first to the second floor, and then right in front of her will be the door out to the parking lot. So she's got one window, and that faces the parking lot. Unlike DM, if you go up those steps and you continue to walk in the great room, make a left, DM's bedroom door is right there. It faces the kitchen. And her window faces the backyard. So their windows are opposite. One faces the front of the house, one faces the back of the house. So again, I repeat, what exculpatory evidence could Bethany have had that would have been helpful to the defense? I'm completely stumped by this.
Mm-hmm. Well, one maiden nut, Eddie says, maybe she wasn't there and she knows who committed the crimes. Wouldn't that be amazing if
the text, though, suggests she was there and said, come downstairs. Remember? Come downstairs.
Mm-hmm.
Run to my bedroom. It's better for us to be together than all. And that was 4:20. Now, I don't want to bring up the timeline, but I guess I'm forced to. We learned from this recent document drop that suspect vehicle 1 was in motion through 4:02 4:07 a.m., not 4 o'clock, as the affidavit of probable cause suggested. The affidavit of probable cause dated December 29th, 2022, signed by Detective Brett Payne, indicated the timeline of the crimes was approximately 4 o'clock to 4:25 a.m. with suspect vehicle 1 seen speeding out of the neighborhood at 4:20. Okay. We understand those are approximations, but I don't get how that could be possible. But nevertheless, we now have detailed timelines from the state. It says suspect vehicle 1 was seen up through 4:07 a.m. and then seen again at 4:20 a.m. speeding out of the neighborhood. What period of time did these crimes occur in? 13 minutes? Taking away the time necessary to get out of the car and to enter the residence and vice versa at the end of the crimes? 13 minutes, 12 minutes, maybe. One perpetrator? I guess it's possible. Is it likely?
Now, Kathy, do you remember if, because I don't remember, there was that Xana, it was determined that Xana did not order a DoorDash.
That
Do
was
we
in the
know if
latest
a DoorDash was ordered at all?
Well, we know from the receipts, from the documentation, these in limine motions are absolutely the gift that keep giving, because we finally have some information as the public. Now, we know from the recent response by the defense to the state's motion in limine that, and this has to do with authenticating records without requiring someone from the organization to come into court and say, yes, that's video from Linda Lane, or that's video from the grub truck, or that is video from wherever, Corner Club, or that's information from the bank. So 404 information, and included in that documentation from DoorDash showing and returning information Xana never ordered from DoorDash to be delivered at 1122 King Road, at least from approximately November, I think it was 2019, through after the date of the crimes. However, certain information regarding Ethan and his orders from DoorDash, we don't know if he ordered anything the night of November or the early morning hours of November 13th. But we do know that unlike Xana, who had non-existent documentation from DoorDash, there were documents that were returned relative to Ethan Chapin's order history from DoorDash. The confusion continues with respect to these documents.
Yeah. I wonder if that affects the timestamp at all. Maybe it doesn't, but it just seems misleading.
I want to throw this question out to you. Purely speculation, not based on facts, based on the First Amendment that allows people to have discussions regarding matters that are in the public realm. I want to ask you, Audrey, you will recall the affidavit of probable cause signed by whom? Yes, Detective Brett Payne, indicated that Xana received a DoorDash delivery just before 4 o'clock a.m. And now the documentation returned pursuant to a warrant served by Detective Mallory, signed off by the magistrate judge, Megan E. Marshall, indicates that Zana had no such deliveries to 1122 King Road from approximately 2019 through 2022. What does that tell us?
I guess she just didn't use DoorDash.
Ms. Potts is
What do you
raising a good
think?
point here. It says that she received, doesn't necessarily say that she made the order, but she received it. Would that suggest that she walked downstairs, opened the door to receive that delivery? And okay, looks like it was ordered from Ethan's account and Zana received it. What does this mean? Does this mean, Miss Potts, and again, we're just talking, not based on facts. No one was there. We don't see the receipts. We don't know. Terminology: ordered from Ethan's accounts, but received from Zana. Could that suggest possibly that she walked downstairs, opened the door, and received that order?
Now, who do we think gave that information to the police? Was it the DoorDash delivery person themselves, or was it the roommates? So how would the law enforcement know that it was actually Zana who received it, but it was on Ethan's, I guess, account or bank records?
Pursuant to the affidavit of probable cause, December 29, 2022, signed by Detective Brett Payne, it does say in there that Zana received a DoorDash delivery. That's December 19th, 2022. Fast forward several months later, there was a warrant that was served on DoorDash, signed by Judge Megan E. Marshall. This was after the case against Mr. Koberger was already opened. And so, therefore, Detective Mowry wanted this warrant issued, and Judge Marshall signed it. So, this is not surprisingly, this happens all the time. It's not until after the arrest that police can then invoke their authority to search and seize property, but law enforcement must sign off on it. But looks like law enforcement did here.
Yeah, I'm just curious who gave law enforcement that information. Because by looking at bank records, you would only be able to see that Ethan ordered it.
Wouldn't there be something at the crime scene? A bag. Whether it was from,
maybe her name was on it.
yeah, as many people seem to think, it was from, what was the name of the restaurant? Drawing a blank.
Oh, Jack in the Box.
Jack in the Box. Wouldn't there have been, if Zana received a DoorDash delivery, wouldn't there have been remnants of a DoorDash delivery, a bag, a receipt, half-eaten food? I would think that this would be available to the Moscow Police Department on November 13th, 2022. But then the question becomes, why wasn't a warrant served upon DoorDash until approximately, it was like December 6th, 7th? Why wasn't it served November 14th? Right? This appears to be the last person who saw or who walked up to the property last time that the people in that house were alive. Don't want to serve a warrant on them immediately. Very confusing to me.
Design Rhythms brings up an interesting point here. It says if DD arrived at 4 a.m., then it had to have been ordered around 3 a.m.
Mhm.
Seems like no actual activity by all 4 of the victims after 3 a.m. That's interesting to think about. What time was that ordered for it
Right.
to actually arrive at 4 a.m.? I don't know,
Now, some
but that's
people
an
have,
interesting thought.
people have, no, I have no firsthand knowledge. I can't confirm this. I can't deny it. Just that people who bring DoorDash deliveries engage in other commerce, marketing activities.
Oh, yeah.
Is the truth. I'd love to know
Mhm.
what Ms. Taylor believes about that DoorDash. You know, some speculation have been out there that it was Brian Koberger who was the DoorDash driver, and we cannot begin to speculate why. There's so much secrecy around the DoorDash driver. If you look at the affidavit of probable cause, Brett Payne literally throws Jack DeCore under the bus. He names him by name. The surviving roommates are identified by initial. The private driver, redacted by name, but you know it's a male. Why the secrecy with this DoorDash driver? Last person to be at the property before the crimes. Would seem to me that would be the first person that you'd want to subpoena and talk to. So I'm quite frankly very confused about that. You know what, when we think of and we look at the recent documentation showing this car going up and down Queen Road, making a 3-point turn, attempting to park in front of 1122, going into the Linda Lane parking lot, wouldn't that suggest a person lost who wasn't, familiar with the property, who's endeavoring to drop off this meal so that maybe they could go home? Plausible, I think, very
Yeah.
plausible.
It just made me curious about what the roommates were doing around 4 a.m. when the DoorDash was supposedly being dropped off.
And wasn't there a call
And
from DM2? We don't know who this person initialized is. However, EG. This is minutes after Xana and Madison were dropped off at 2:19 a.m. Additionally, no prior time before this information was finally disseminated to the public was the public aware at 2:53 a.m. that Madison called BF. This was at the same time, supposedly, that Kaylee and Madison were also attempting to get a hold of Jack D. Why out of the blue is Madison calling BF at that time? This may be one of the last known contacts of Madison while she was alive.
so I think it's just interesting that 9 minutes before the DoorDash delivery, DM does create the new contact. And
But
then
that might, a lot of people make a lot of, big deal about this. I don't think so. This might have been a contact that she received a
No.
day or a due days before she decides to put it in her phone. We've got to stop, in my opinion.
True.
It's imposing our thoughts on what these two roommates should have done. First, you're 19. They're not in their 30s and 40s and 50s as we are, at having that life experience. And I do not believe for 1 second that two 19-year-old girls would have remained in that house with 4 decomposing bodies in it if they knew for a fact of what happened. That's just my opinion. I think that 911 call was very real. I will not listen to it again. I am kicking myself that I listened to it at all. But I think that, to kind of sit here, as many people are, and nitpicking as to, okay, so she puts it in her phone, she's going on social media. That's what they do. I know a lot of, and I know many people here also know a lot of teenagers. It's what they do. They live on their phones. Look at this. It's like
Well, I'm not
4:22.
necessarily trying to blame them. I'm just trying to figure out, well, where are people in the house while this is happening? And I
They
do
were
know
dead.
that they were saying that Zana was also on her phone at 4:12.
Very
So
confusing.
just a few
Very,
minutes after that,
very
left
confusing.
DM. So that was more I was wondering. It's just
Yeah, I'm not saying
the
you.
positions in the house.
Saying other people. Other people have sat here and have gone through this documentation and have imposed, I would have done this, I would have done that. You don't know what you would have done in that type of a situation. I fully believe, just by looking at what I've seen, I don't see any involvement by them. And I'd like to see some facts that show that what they did was to hide what happened here. I don't see it. I am Lux saying, I don't think they were alive by 4. I am Lux. Why do you feel like that? You feel that the timeline might have been earlier even than law enforcement is providing here.
Yeah. Oh, Mommy Ball. Oh, welcome. Yes, wasn't it on her TikTok? I guess she could have been on the computer too. I just assumed phone. Did we lose you, Kathy? Are you still here?
Hey, sorry, I had to go get some water here. Sorry about that.
Oh, okay. Well, welcome back, Kathy.
Thank you. Now, I believe what Ms. Potts is saying here. Defense has already stated that Dylan went to Bethany's room. They stayed there and never left. I agree. I think that's exactly what happened.
Okay. Yeah.
So we have a lot more documents that will probably drop tomorrow, like the defendant's reply to state's response to defendant's motion to strike DP regarding autism, inconclusive data. Those are unfortunately under seal. But Audrey, if we could go to the next page, please.
Sure, let's go.
Okay, there we go. Sealed defendant's proposed jury questionnaire. Motion to seal jury questionnaire. There's going to be a hearing on the 16th of April regarding that. Unfortunately, closed to the public. Really getting close to trial, people.
It'll be here so quickly.
So thanks.
Oh, welcome to Faster, please.
Yeah, I
Kathy
keep it
does pack
short.
a lot of info in her short bit.
That's it. You know, my
awesome.
channel is not for everybody. It's for people that are seriously interested in the documents. I just basically say what the documents have and refer people to go to the court records and make up their own minds. But I don't know. You know, I ran a poll recently. We have 80 or something like 78% of the 500 people that took the poll believe that there's reasonable doubt here as of right now. So it's going to be really crucial what happens after these hearings on the 9th and 10th. Because those hearings, whatever Judge Hippler rules, will change the course and scope for the rest of these proceedings. No question at all. Is anyone planning to go to those hearings? No? Yeah, there we go.
I found your poll, Kathy.
Oh,
if
thank
anyone is
you.
interested, I can post the link. I can
Mhm.
get the link now, too. This is a great poll.
Thanks. No, I mean, people are really feeling that there's a lot of reasonable doubt still in this case. And it will be very interesting to see what happens after the 9th and 10th. Because again, Audrey, however Judge Hippler rules, that will mean what evidence can come into the case and what's going to be kept out of the case. So important.
Wow. And to think that on the 9th,
Right.
I think like you were saying, that's a very important hearing, right?
Very important. The 16th is closed to the public. That's jury instructions. But the 9th is the hearing on the motions in limine. 9th and then, if necessary, going into the 10th. Audrey, you're going to be live, right?
Yes.
Yep.
Yes.
Yeah, Hippler tends to give us clues regarding how he is receiving what he feels. The defense and state are arguing. There we go. There he is. What do you guys feel? Do you feel that he is the better judge to preside over this case? Should it have been left in Latah County? Some people even feel that maybe the defense is regretting moving this hearing, moving this venue, and that maybe Mr. Koberger would have had a better shot in Latah County. I don't know. I don't know. Okay. We're getting a lot of comments that people feel that that Judge Stephen Hippler is the better judge for this case.
Welcome, Taka. Good to see
Right.
you.
Mm-hmm. Audrey, now that we've finally gotten some information from the defense and some information from the state, what, in your personal opinion, do you think that is the strongest bit of evidence in favor of the state and against Mr. Koberger? What do you feel is the strongest piece of evidence against him?
The strongest piece of evidence I feel is the DNA. The strongest evidence for him, I think, is the cell phone data.
Mm.
How about you?
Yeah, I think that's a really good analysis. Even if the cell phone data cannot be used in the alibi defense, it can still be used with
Yes.
other motions.
Mm-hmm. Yeah, it'll still be used at trial,
Right.
regardless if it comes in as alibi. Mm-hmm.
Does anyone have any, and again, 100,000% speculation of who the target was, whoever the perpetrator was, whether you feel it's Mr. Coburg or whether you feel it was someone else, who do you believe was the target based on what you know now? We're just a few months from trial. It's almost 3 years since the crimes at King Road.
Well, I
Well,
personally
4.
believe that it was Ethan.
Mm-hmm. You were saying that. That is such a compelling theory. Such a compelling theory for multiple reasons. Can I tell you why? Again, we
Yes,
don't know.
please.
We don't have access
Right.
to all of the evidence. So much information still remains under seal. There's also the gag order on top of it, although Stephen J. Hippler, district court judge that you're seeing here, has ordered certain items to be released to the public. There's still so much that's not. I feel compelled, number one, the Moscow Police Department first said that this was an attack that people in the area should not be concerned about. Do you remember that? Because it was personal, personal to either one of the victims or or the home or the house. Ethan was the only person who didn't live there. Ethan lived at Sigma Chi, surrounded by many, many, many brothers who, if anyone wanted to attack him, it would have been more difficult there than at, I believe, and again, it's 1,000% speculation, not basing this on any facts. It would have been a lot easier to get to him at 1122 King Road, where he's surrounded by women. Secondly, the comment, they didn't have to go upstairs. There has never been a reasonable explanation for that. That's almost like something that was slipped that got out. Right? Do you remember, Audrey, that comment? I don't know if it was he
Yes,
or
it was
that.
beginning, authentic. Maybe didn't mean to. Yeah.
Right. It's almost like excited utterance that we hear about before people have an opportunity. And then, there was some, tried to backpedal and there is no, I don't know. I just think, I've lived a long life, met so many people, have had many experiences professionally. The idea, the statement, he did not have to go upstairs means one of two things. He did not have to go upstairs from the first to the second floor, or he did not have to go upstairs from the second to the third floor. There's no other floors but those 3. So if that's true, that limits that statement to either going upstairs from the first to the second floor or going upstairs from the second to the third floor. Which do you think is more plausible if that's true of those 2 statements?
Yeah. That it would have, maybe he meant that it did originate on the second floor instead of the third floor. He didn't have to go up there. It wasn't a part of the original situation, maybe.
So maybe, again, 1,000% speculation. I'm not basing this on any fact at all. None at all. Total opinion, speculation. We've heard that DM thought that she heard Kaylee run downstairs, maybe say something like there's someone here, and then run upstairs. So maybe again, speculation, the perp followed her. They didn't have to go upstairs. Possibly because the target was on the second floor.
Yeah. That makes sense.
Mm-hmm. And then, Audrey, if we might refer back to the affidavit of probable cause, it is document number 1 on the court record, first item filed. I can almost see it in my mind. I've looked at that document so many times. I've looked at it, backwards, forwards, upside down. I could see it in my head. There is a first full page of information which begins with Detective Payne providing his credentials, providing a little chronology of what happened after he arrived at 1122 King Road on the 13th of November, 2022 at approximately 4 p.m. or thereafter, with Sergeant Blacker in the car with him. There we go. If we go down, do we see here? Okay, this is Exhibit A, statement of Brett Payne. The information below is provided by Brett Payne, duly appointed, qualified, and acting peace officer within Latah County. Go to paragraph 2 at November 13th, 2022 at approximately 4 p.m. Moscow Police Department, Sergeant Blacker, now Captain Blacker, and I responded to 1122 King Road, Moscow, Idaho, to assist with scene security and processing of a crime scene. So by 4 o'clock, it was no secret that something horrendously happened at 1122 King Road, and therefore Sergeant Blacker and Detective Payne arrived there to assist with the processing of the crime scene. Upon arrival, meaning just imagine that front parking lot, Detective Payne and Blacker pull up in their Moscow Police Department issued car, get out of the car. They're met by who is believed to be one of the first responding officers. Smith meets him and decides, and for whatever reason, he would walk me through the scene, not us, but me through the scene. Next paragraph, Audrey, please. So Officer Smith and I entered the King Road residence. This would have had to have been through the front door, first floor, right, Audrey? And it says right through the bottom, first floor door on the north side of the building. There is no first floor door on the other side of the building. So this had to have been through the parking lot. Officer Smith and I then walked upstairs. So it would have been literally opening the front door and you're hit with the steps right there. You go left, you go upstairs. Walked upstairs to the second floor. Smith directed me down. So you can just imagine they get upstairs to the great room. Smith directed Payne to make that right, to go down the hallway towards Xana's bedroom. You can just picture it in your head, right? You can just imagine this in your head. Directed me down the hallway to the west bedroom on the second floor, where I later learned through Xana's driver's license and other personal belongings found in that room, Xana Kernodle was there. Okay, this was her room. Before this room, I don't know why this is put in here. It's kind of weird to me why he's pointing this out, but he is making a point of saying that just before this room, there was a bathroom door on the south wall of the hallway. Why is this thrown in here? Nobody was found in the bathroom, but he does. So we have to, this is page 1 of the PCA. We have to conclude that this was an important point to Detective Payne. Because why else would you say just before this room there was a bathroom door on the south wall of the hallway? Did something happen there? Was there some residue of a struggle? BLOOD, of a fight? We don't know. Just before this room, there was a bathroom door on the south wall of the hallway. As I approached the room, I could see, later identified as Colonel lying on the floor. What I think happened here is I think that before the 911 call was made, that either the roommate or both of the roommates and the friends that came over saw this. Maybe they didn't go into the room, but saw it from the hallway and thought maybe that there was an OD because she was drinking the night before. Total speculation. As I approached the room, I could see Azana laying on the floor. Okay, and he makes an observation. Audrey, do you see here? He makes an observation of what the cause of D could have been. Wounds which appear to have been caused by an edged weapon. But look at the different treatment regarding the next paragraph, also in the room. Okay, so this should quell the speculation that Ethan was found in the hallway, that it was found in the great room. It says right here that also in the room, and this is Xana's room because this is what he's talking about. Also in the room was a male, later identified as Ethan, hereinafter Chapin, was also unalived with wounds later determined per autopsy report. And we see the big redacted there, to be caused by sharp, forced injuries. Is that the same thing as what the wounds that Xana suffered, caused by an edged weapon? Edged weapon, sharp, forced injuries. And then everything is redacted here. Everything is redacted here. He cannot make a conclusion. Detective Brett Payne cannot make a conclusion regarding what the cause of unaliving was to just one of the four victims. And I think that's powerful evidence right there. I really do. Audrey, what do you think?
I absolutely agree. Yes.
So we see here, now if you go to Commonwealth of Pennsylvania versus Koberger, you'll see they don't care. They name everybody and they give the name of the ME who tended to Ethan and made the determination of what his cause of unaliving was. And if we could go down just a few steps here. So it seems to, it just seems to be that Ethan was treated a little differently. And it might be just because of the wounds that he suffered.
Mm-hmm.
Okay, then it says, I then followed Officer Smith upstairs. And you can just picture it in your head that they turn, they walk out of the area where Xana is and Ethan was, past that bedroom now on the right-hand side, go out into the great room, make a right, make a left. They go up that step, and right there to the left would have been the bedroom of one of the surviving roommates, DM. To the left would have been the kitchen. Walk upstairs. There's a few steps. There's a little landing area. Then turn and then go up the remaining steps to the third floor and into Madison's bedroom, when he sees here that the third floor consisted of 2 bedrooms and 1 bath. The bedroom on the west side was later determined to be Kaylee's. The dog wasn't there at that time. He had to make that determination by looking at body cam imagery of Officer Nunez, which I believe was the first responding officer at the scene because of his, we've seen in the in limine motions, the fact that he spoke with the witnesses upon his arrival, including DM. So Nunez now has gone up to the third floor. He's found the dog in Kaylee's room. Payne then turns his attention to the other bedroom, and that's where he finds Madison and Kaylee. Both were deceased with visible. And again, he makes a determination as to the cause of the unalivings, which he did not make with Ethan. And Ethan is the only one he did not, because we see here, he says that they were found with visible S wounds. I later noticed. Now, it does not say he immediately noticed this. It says, I later noticed what appeared to be a tan leather sheath lying on the bed next to Madison's right side when viewed from the door. There's some discussion that this sheath was found under Madison, under the blanket. It's like it's moving all over the place, but nonetheless, the sheath was later processed. This would have been by ISP and had K-Bar USMC and the USMC Eagle, Globe, and Anchor insignia. So he's describing what this sheath is. And if you go on and you can read the rest of the affidavit of probable cause, you'll learn about where the roommates were. The only one who's not accounted for is DM in this affidavit of probable cause, what time they arrived home, and so forth. And we see here that there were multiple calls made from, or contacts from Kaylee and Madison to Kaylee's ex-boyfriend. We were not privy to facts that Madison placed a phone call to BF at 2:53 a.m.
That is so interesting. I don't think that Brett Payne could recognize the injuries on Ethan when he arrived to the scene. And the injuries were so significant that the medical examiner had to write about them. And they are the only wounds that had to go, or lack of wounds, whatever they were, that went into detail in the redacted version of the PCA.
Right.
So I do think
Right.
that that's significant in some way.
Yep. Yep. It's just, it seems like of the four that Ethan was treated differently. Why wouldn't Payne say right here in the PCA what the wounds were caused by? He had to get that information from the medical examiner.
Yes, it doesn't seem like he has any hesitation about, visually describing the other wounds. But for Ethan's, yeah, he made a decision not to mention them, or it just seems like he couldn't identify them.
I
But
wish
he's not
that
afraid to say he recognized it.
I wish
ahead.
that they would tell us what the sequence of these horrible events were. Who went first? They have to know that, especially if it's one weapon. And even if it's not one weapon,
Mhm.
to have some information if it was Madison first, then Kaylee, then Xana, then Ethan, or some other sequence. Once the public learns that information, I think it will lead to an opening of the floodgates by the public. I don't know why that continues to be under seal. I simply don't.
Okay, well, that's interesting, Heather. Heather says she thinks that not describing the wounds on the scene is strategic and in no way because Payne could not see what happened to Ethan. That's interesting too. That could definitely be as well.
Point. I think that we're going to hopefully get some more kernels of information because these motions will be argued in public, I believe, to Judge Stephen Hippler, who will have to make a ruling on all of them. And I think that once the public learns without any debate who was first, who was second, who was third, who was fourth, that number one, the target will be a little bit more known. And number two, there will be no question that it was someone other than who the official records say.
Oh, this is interesting here. Design Rhythm says, it's very easy to tell when someone wants you to understand a visual compared to when they want you to be confused. That's an interesting statement.
We refuse to be confused, because that's what we do. We
Yes.
focus on the documents. We don't take our information from speculation, from it could have been this, it could have been that, it could have been something was planted, something was not. There were, this was a D deal. This was some sort of retribution until or unless we see, and this is from the defense as well. The defense has had no problem coming out and arguing their position. It will be extremely curious to learn what the parties, what the defense, what the state, how they frame their motions, their responses, their replies, and what Hippler will ultimately rule, because that really is all that matters. Judge Hippler is the only person in the world who can make these determinations, and they are coming up very soon.
Very soon.
Mm-hmm.
I think it's also very interesting here what Ms. Potts says. She says, defense just disclosed that they have a forensic pathologist that will argue against the state pathologist regarding wounds and injury patterns. I think that's very interesting because that goes directly to timeline.
Right. No,
depending on. Mm-hmm.
Go ahead. I apologize. I so apologize because you were talking such an important point here. There is nothing here more important than this timeline, I think, for helping to begin to understand the pathway, how we got to where we are right now with the case, and, who is responsible for these horrendous crimes at 1122 King Road. What do you think?
I think that from a medical standpoint, the nature of these wounds will indicate maybe if there were multiple weapons, how long it would take with each victim. And that could shed a lot of light on multiple. It actually could provide more reasonable doubt as well. There is so much that could be determined medically.
Mm-hmm. So what do you think?
About the nature of the injuries?
Yeah.
Well, from what Payne was saying in the PCA, I think that they are different. And when they are different, that would make me think that whether one perpetrator or two perpetrators, they would have to take a different amount of time with each one. And it would also suggest, the movements within the house, the order. And I'm also wondering if there was time between each one, because if the timeline is off because of the medical information that we received, then that could actually space out the time this person or persons took with each victim. Because once we realize what happened medically, anything could be thrown out the door, anything could come in as well. It's just, for me, this is like, from a scientific medical point of view, I am just waiting to hear all of these types of facts, because this will cement what the true timeline is and the true events, depending on the nature of the medical stuff.
Can you believe it? It's almost 3 years. 3 years, and we still don't know so much about the case. We still don't know.
Well, this is interesting, Ms. Potts. She says, remember a while back, the defense disclosed Barbara Wolf, Chief Medical Examiner of Florida, District 5, and happens to write books about recognizing staged crime scenes.
Yeah, she Hitler wouldn't allow her to testify either that day. Remember?
Hmm?
Yeah, she was scheduled to testify. I think it was at the DP hearings, and Hitler didn't have her testify. He told her no, didn't need her testimony because he was relying on her declaration.
Let's see. Meg P, welcome. Hello. Oh, welcome to Fast for Flea's best name, and JB, Amy Conway. Meg P says, Idaho Code 194301. As soon as the coroner is informed that a person in his county
Right.
has passed, shall go to the scene of the passing and take jurisdiction over the body. That is a great point because, as we know, the coroner wasn't able to do it on this case.
Not until much later.
Mm-hmm. That is very odd. I would have liked to hear Barbara Wolf testify. Hopefully we get to at the actual trial.
Yeah, maybe she'll come back for some other purpose. But Audrey, I have to run. I got an early morning tomorrow. I want to thank you for inviting me. This was great.
Thank you.
Big day tomorrow.
Love to have you.
We're going to wait to see what these documents say. They are going to be so important in the case. So I'll be back. I want to thank you for your time. I want to thank you for hosting this wonderful event. And thank you to everybody in chat, all the mods and everyone else, all the visitors who joined us here today. So I'll talk to you soon. Okay, Audrey?
Talk to you soon. We'll have you on soon. And thank you for coming.
Okay.
Always a pleasure.
My pleasure. Bye, everybody.
Bye. Wasn't that great? Kathy is such a great guest. All right, everybody. Thank you all for coming today. This was a great conversation. I will see you all next time. And I'll be live on April 9th to stream the hearing. Thank you all for coming. Bye.